to all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
All right, good morning, and welcome to the beginning of the 25-26 court term and today's sitting. The panel hearing your cases today consists of Justice Gregory Massing to my right. My name is Ariane Vuono, and to my left is Justice Jennifer Allen. I want to take a moment and extend a special welcome to Justice Allen, who is the newest member of our court, having been sworn in by the governor this past summer. Although this is not her first sitting, Justice Allen went right to work as soon as she was sworn in, and she's already heard a number of cases. But we are happy to have her with us and will continue to, I'm sure, benefit from her expertise. We have 5 cases on the list for today. We will take a break after the 3rd case. I want to remind everyone here that we've read everything that you've submitted to us. You have 15 minutes to present your argument. That's not a long period of time, so please get right to your most important issues. And I also want to remind everybody that we have no rebuttal in the appeals court. So with that said, I'm going to call the first case, and I see counsels are already here, ready to go. Commonwealth versus CECIL Baldwin, number 2024-0862. Good morning, Counselor.
Yes, good morning. Good morning, Justices. I just wanted to remind the court that this is a case that is here in the appeals court as a result of a Commonwealth versus Gomez or 2 conditional pleas out of the
I'm going to interrupt you and ask you just to speak a little closer to the microphone or pull the microphone closer to you. I'm just having a hard time actually hearing. No, you can leave it. No. Uh-oh. Okay. Yeah, there you go.
I hope it's working.
It is working. Looks like you just need to be closer to it. And we're going to get some assistance, I see, right away here.
Okay. Just wanted, again, to remind the court
A conditional plea. That's correct.
The case is here on 2 conditional pleas that were out of the Springfield District Court.
Just to be clear, the 2, not 3, so that the OUI conviction is not being appealed, basically.
That was not conditional, it was an unconditional plea.
Okay.
And of course, and I think you'll see in my sister's brief and in the record, the 3 charges were all combined with respect to the 431 days that he was incarcerated.
All concurrent, right.
So, and I think you'll also hear my sister's argument on the superfluousness of this, since, but
we'll get to
that's
that.
for another
Okay.
moment. I did further want to just give a couple of dates to the court before I proceed with my argument. On 12/16 of the date in question, the trooper asked the gentleman to pull over. At a certain point, she got out of the car, and he did pull over, and she was on the passenger side of the vehicle, and then subsequently at 12:21, Trooper Wola, the second officer, arrived. Trooper Wola then at 12:21 asked, well, he's on the strike that on the driver's side, asked Trooper Martineau, shall I get him to hop out? And he then asks the purported defendant to get out of the vehicle.
We've watched the video.
Pardon, Judge?
We have watched the video.
Yeah, both videos?
Yes.
Yes, okay. And just one other, so at least a few other things. Trooper Wola, after he arrived, he got the person out of the car, brought Mr. Baldwin to the front, and Trooper Martineau started conversation about his impairment and some subsequent field sobriety tests, and then the Trooper Wola goes back to the vehicle while the defendant is at the front and opens the door again with a flashlight and looks in and retrieves him.
So is your point that that was an independent action on the part of the trooper at that point, that when the judge found that the trooper had actually seen the cocaine in the passenger side door, that is somehow erroneous?
Well, I'm just suggesting that was at least the position of the trial counsel. I know that we review only clearly erroneous, but I just did want to bring it to the attention of the
Okay.
court. That transaction of he takes him out of the car, the door is shut, takes him to the front of the car in a minute, and some seconds later goes back and opens it with a flashlight, looks in and retrieves the drugs, which, of course, I say in my brief, and you saw in the video, has a paper or some tinfoil black.
Recognizable to the trooper as what he referred to as 94C, cocaine.
Yes. At some point, then, at 12:23, Mr. Baldwin asked Trooper Martineau, "Am I arrested?" And and again at 12:26, and at 12:38, Trooper Martineau says, "Well, you're still being detained." During that,
You know, Counsel, we really are familiar with the video and the facts. We've taken the time to look at it beforehand. So let me ask you a question, if I may, about the case. Right? Seems to me one of your main points is whether or not the judge could rely on, the motion judge could rely on the fact that Trooper Waller did not testify and Trooper Martineau did testify as to what Waller, saw.
Yes.
Right?
Yes.
Okay. How does that square with the fact that the judge also saw all the body-worn camera video that we've also been able to see?
So you're,
In other words, it doesn't really matter so much I'm asking you, how much does it matter what Trooper, I think it's Martineau, if I'm pronouncing it correctly, right?
Yes.
Okay. It doesn't really matter so much that she gave the judge an explanation or conveyed to the judge during her testimony what she was told by the other trooper, because the judge had the video camera and could see what the other trooper did or did not do during the course of the investigation.
well, I'm suggesting, however, Judge, that Trooper Waller should have been there to at least give his rendition of what.
What more could he have said other than what we can see on the body-worn camera? I mean, we see everything on that video that he
Yes,
did, right?
Yes. Yes, you do. You see Trooper Waller's body-worn camera that was submitted by defense counsel.
Right.
Yes, you see that. And the first, of course, Commonwealth's exhibit was just Trooper Martineau's. So yes, I'm aware of the.
Yeah. No, I didn't think that you weren't. Don't take it any other way.
Right. So I'm just suggesting, though, under the Commonwealth versus King, that the plain view observations by Trooper Waller should have been presented to the court at the hearing, and not in the statements that he also made to Trooper Martineau should have been presented by him at the hearing on the motion to suppress. And I know there's.
Well, isn't that in King, the reason for that is that the non-testifying officer is the one who concludes that the green leafy substance is marijuana. The officer who testified had no knowledge about what the green leafy substance was, and so the only evidence on the record is the green leafy substance could be, lettuce. It's not like we couldn't tell from the video that was cocaine.
Again, the question you're asking me is, it will.
I mean, isn't King, lettuce versus cocaine?
Right, exactly. Well, again, the observations of Trooper Waller should then, again, as I say, should have been presented at the court. He's the one who went whether on the first go-round, happened to see it,
okay,
and went back with his flashlight.
So why? You say it should have been. Why? Why does it matter?
Because I do not think in this particular situation that Trooper Martineau should have been allowed, over the objection of defense counsel, to testify. I mean, it is hearsay, obviously, but to testify about the statements that Officer Waller made to her,
Okay.
as to the goings-on of what he saw, what he found, and also to his plain view observation. He simply said to her, 94C. And I don't know, 94C is 94C.
Well, 94C is a reference to cocaine.
Yes. Yes.
Really, yeah. Let me see if I can take you a step further, and that is to Justice Massing's point about what does it matter. In even a larger context, the judge then goes on to determine that everything that was in the car would have been inevitably discovered. So if that's correct, your arguments, even though well-made, really don't matter anymore, if I may be so blunt, right?
Yes.
Okay, so if anything is wrong with the judge's conclusion that everything in the car would have been inevitably discovered because the car was unregistered, could not be driven? We could all see what a dangerous position everybody was in on the side of the road on 91, just outside of Springfield. Not a good place to be parked, for sure. So the car was going to be towed, and everything was going to be inventoried.
And as I believe when you read the transcript of the hearing, and strike that, the findings of Judge Malpe, he says, well, even though the inventory search was premature, because again, we get to the tow policy, they would have inevitably found
Premature,
it.
okay, that's premature, but that doesn't make it invalid.
Well, I guess I'm just saying a policy is a policy. Why didn't they just wait? I mean, I do have the times they called for the tow. Well, the field sobriety tests were going on. And I believe that...
The car was not towed, however, until after the defendant was arrested, correct?
The hookup was at 1 a.m., 02:47. But again, several times during this interchange, during this proceeding, the trooper said, Trooper Martineau said, he said, am I arrested? She said, no, you're detained. Then he asked 2 more times.
I want to direct your attention again to the fact that from the get-go, the troopers knew that the car was not registered.
Yes.
Isn't that fact? Is that the most critical fact, really, in terms of the tow?
Yes, it is. I simply would...
The car could not have been driven away by anybody.
Correct. It would have to be towed. I'm just suggesting that there are policies, there are procedures. I mean, okay, so it's a warrantless search. Oh, he looks like he's OUI, so why don't we just do everything right now? So forget the policy. We can order the tow. We can go and search the car, which, by the way, Trooper Waller did while Trooper Martineau was conducting the field sobriety tests. And if you recall, the third trooper, and it's a couple of seconds only, and unfortunately is on Trooper Waller's body-worn camera, you see the third trooper, Trooper Waller says, watch her while I search. So the third trooper in the shadows has his body-worn off, and he's watching the field sobriety test and Trooper Martineau. You just see the trooper doing that. So I'm suggesting then, why have a policy for anything? It's just like, it looks like he's drunk, let's do it all. And I'm suggesting these procedures perhaps should be more in compliance with what is stated. Yes, everything is inevitable. The driver was clearly impaired.
Well, not everything is inevitable. If the car had been registered, if the car had been insured, if the driver was not impaired. So not everything is inevitable. It's just that the facts in this case seem to suggest that the inevitability here.
Yes.
So they suggest. We haven't made a decision yet.
I completely am in
You've been very candid, and we appreciate your argument.
Just going further, I'll go no more other than to say, finally, the tow truck was there, and you see that Trooper Martineau says, okay, you're arrested. She went from detained to arrested, and I think it's at 12:36 and 12:38. And I did, when I went laboriously through these 100 times, had occasion to see that from the original stop, 12:16 to 1:02, that was the amount of time that they were by the roadside, and these matters occurred. So again, we're simply, the defendant's assertion is that properly, at least, or at least from defense counsel and the defendant's point of view, it would have been helpful to have, at the hearing, Trooper Waller come in and say, this is what I did, this is what I saw, this is how it went down, these are the observations I made, and to have the defense attorney be able to cross-examine him, which was over his objection because of the hearsay info that Trooper Martineau was putting in that did not occur.
Okay. Thank you.
Thank you.
We appreciate your argument and also your meticulous attention to the details. Thank you for that.
Thank you.
Counselor?
Good morning, Your Honors. May it please the Court. Elizabeth Simonian for the Commonwealth. I'll start by saying that the motion judge properly denied the defendant's motion to suppress in this case. First, we look at the fact that the collective knowledge doctrine limitation that the defendant relies on here, pursuant to King, it does not apply. The first point I'd like to make on that
Would you say it doesn't apply, or would you say that King is distinguishable?
King is definitely distinguishable, but on the facts of this case, we look to how the motion judge based his plain view findings on it appears to be based on the trooper's body-worn camera footage, which the defendant entered himself into evidence at the suppression hearing. And it does not appear that the motion judge mentioned the collective knowledge doctrine anywhere in his plain view findings. Rather, he based his exit order findings on the collective knowledge doctrine. But again, even if we bring the collective knowledge doctrine into the case under the plain view findings, as Your Honor Vuono said, it's entirely distinguishable. As Your Honor Massing said, it is lettuce versus cocaine here. And then we look to the fact that our testifying officer was able to view the substance. She believed, based on her training and experience, that it was cocaine. The passenger door was open where she was standing compared to where Trooper Wohler was standing on the driver's side. They were in close and continuous communication the entire time. So this wouldn't be trying to offer, as in King, it wouldn't be the Commonwealth trying to use one witness who never saw the substance to offer the hearsay observations of another non-testifying officer. These are two officers who were speaking to each other the entire time. They were working as a team on a mutual
So do I
objective.
understand your point to be if, for example, hypothetically, the body-worn camera video of Trooper Wohler had never been introduced, that would not have made a difference? Because as far as your argument is that that his observations could have been imputed upon the other Trooper Martineau no matter what.
Correct.
Okay.
But again, even considering if that testimony was improperly before the court, we do have that body-worn camera footage where the motion judge could make every necessary determination about how it was found, how it was observed, and you know, he could just see everything that was going on there, and that was why it was a proper basis to find that the Trooper Wohler's plain view seizure of the cocaine in the driver's side door panel was justified.
What do you say, Counselor, about your sister's point that there are procedures, there are rules, there's an inventory policy,
Yes.
And there's a reason for them, as we know. I mean, some of us remember the days when they didn't have them,
Yes.
and we do now, and they're written, and they're introduced regularly, et cetera. What do you say about the fact that she says they should be scrupulously followed? And in this case, fair to say that that tow truck came fairly quickly. The stop was still ongoing.
Sure.
Decisions had not yet been made, and they were ready to go. What do you say about that?
Yeah, so I would start with the fact that we have the Massachusetts State Police Policy. There's two theories that they may tow a vehicle. One's based on the operator, one's based on the vehicle. So from the outset, as you had mentioned in my sister's argument, we know that the car is unregistered and uninsured. So that creates its own independent basis to tow the vehicle. But if we look to the operator theory, there's 4 criteria to be met before the bold and underlined "and" in that theory. If you look to Commonwealth's Appendix, page 8, you'll see the tow policy. So only one of those 4 criteria need to be met. So that could be whether the defendant is arrested, whether the defendant is unfit or impaired, properly licensed. There's one more that I can't get off the top of my head, but it is highly unlikely to see in every case where every 4 of those criteria would be met, and so only one of those criteria are required to be met. The driver,
So bottom line, your view is that the policy was followed?
the policy was
indeed.
followed,
Okay.
correct. There is no timing requirement. If we're looking at the plain text of the policy, which we need to do in this case, then we see there's no timing requirement. It doesn't say that the defendant needs to be arrested before the tow procedure is initiated. And that, I believe, is what the argument is where my sister sees the problem, is the tow is initiated before the defendant was arrested. As you had pointed out, the defendant wasn't formally arrested until the vehicle was the vehicle was towed after he was formally arrested. But either way, even if he was
No, I didn't check. I mean, I will check. When your sister says that the hookup was at 1.02, at that time, had the defendant been arrested? Do you know?
I do not know 100%
All right,
sure. I
doesn't
know
matter.
he was detained.
We'll look at that.
Okay, he was detained at that time. I do know that, but I don't know if the formal arrest.
He was informed about being detained fairly early on,
Yes.
right? Okay.
But again, even if the arrest happened too early, we have other independent bases to rely on to make sure that that tow procedure was proper. Taking away the tow procedure, if that is deemed improper, we also, in the alternative, have the automobile exception here. For two reasons, the automobile exception applies to discover the marijuana and the cocaine found in that car. First, when Trooper Martineau, she has the anonymous tip with the erratic and concerning operation. She observes that herself. She corroborates that tip. She then views there's a bunch of impairment behaviors that we can see which are quite concerning, and she observed herself. And then she sees the bottle of alcohol on the passenger side seat. It's opened, but it's not empty. That itself establishes probable cause to search for additional OUI evidence. And then when Trooper Wohler plainly viewed that cocaine in the driver's side door panel, that's a second basis for the automobile exception to apply. The last point I will make here is that even if there is a hypothetical reversal of the motion to, the denial of the motion to suppress, the defendant's conviction was unconditional as to count 3 for OUI drugs. So it would not affect that. And if there are no further questions.
Wouldn't it affect the sentencing? I mean, if two of the 3 were out, would the judge, shouldn't we remand for resentencing? Or was it time served, right?
He did, yeah.
It was 461 days was time served.
I believe so, yes. So the question is, would it affect the sentencing?
Yeah.
Mm-hmm.
I can't make that determination, possibly, but possibly not. But we know that the Commonwealth still has a viable case here. This entire case itself is very, very strong for the Commonwealth, but it's still viable even with that count 3. So if there are no further questions.
Wait, just hold on a second. I'll
Sure.
check with the panel. There's more questions? No? Oh,
Great.
I see none.
Sure, I'd respectfully request that this court affirm the motion judge's denial of the motion to suppress.
All right, thank you. Thank you both very much for your arguments. All right, I'm going to call the next case, Commonwealth versus Carlos Cuba, 2024-0185. And please inform the panel how your client likes to have his last name pronounced when you start. And I don't believe I said the number, 2024-0185.
As far as the pronunciation, Judge, I think it's just Carlos Cuba.
Cuba, okay. I just want to be sure. Thank you.
May it please the Court, my name is Attorney James Methie. I represent Carlos Cuba in this appeal. The first issue in my brief is that the judge should have allowed defense counsel's motion for required finding of not guilty. The principal and main evidence that my client was involved in the crime is this partial fingerprint obtained from the door frame of Mr. Thomas's car. No one identifies him at any time, either prior to the trial or during the trial, that he's involved in the crime. Mr. Thomas, the alleged victim here, never indicates in court that that's the person who stabbed me or that's the person. Defendant is in the video, and obviously prior to trial it didn't happen either.
So could the jury, I mean, he goes as much as to say as the guy who stabbed me is the short Hispanic man in the video in the gray shirt.
He didn't say in the video.
I mean, he's looking at the video. He goes, he's looking at the video, and he says he's the short guy. He's the guy in the gray shirt there. right?
He identified him as a short Hispanic man, right?
Yeah. And he says in the video that, as he's looking at the video, which is being shown to him during his testimony, he says he's the guy in the gray shirt, not the guy in the red shirt.
Right, you can identify articles of clothing that people are wearing during this fight.
But so, I mean, could the jury reasonably conclude that your client had the same height and build as the guy, as the short, as my guy in the gray shirt in the video?
Well, they could see that he was probably in court a shorter man. Whether he was Hispanic or not, I don't think from the video that's particularly clear. I would disagree with the Assistant DA's mentioning that it's clear that he's a Hispanic man from the video. I really can't tell that. I don't think the video is...
Yeah, no, I think, I mean, I was just asking about height and build.
Pardon me?
I was just asking about height and build.
Right.
I mean, they can see, it's very small picture, right, a teeny little picture, you can't, not very good.
Right.
But there's testimony about your client's height, and they can see him right there.
Well, I guess it would really be up to the judge to make the determination on the required finding motion whether the evidence was sufficient or not.
Right, but I'm asking you,
Well,
could the jury reasonably have made the conclusion that he had about the same build and height?
Well, I think it's still a lot of speculation to say that that person sitting in the courtroom is that person in the video.
That's not the question that Justice Massing has asked you. He's asked you, could the jury reasonably infer that the person in the courtroom and the person in the video had the same height and build? Just that particular
Same height
fact.
and build, sure.
Okay, thank you.
There was no DNA from my client in any of the items tested, including the 3 knives that were in Mr. Thomas's car. And the case law, as you know, states that the Commonwealth has to prove that the fingerprint was placed on the item at the time of the commission of the crime. Now, there were 7 identifiable prints on that driver's side of that car.
So let me interrupt you and ask you another underlying fact. Could the jury reasonably infer that the person in the gray shirt seen in the video placed his hands in that area and could have reasonably left that fingerprint?
I think you can tell from watching the video that the shorter man does open the door 2 times and enters the car.
Okay.
But if you look at the exhibit from the trial I put in my appendix, and you look at the immense amount of fingerprints that are on that driver's side of that, between the door panel, the door, the window, and even the roof, the top of the roof line, there's an awful lot of fingerprints on that car. And there's no testimony that the fingerprint was fresh. And the case law does say fingerprints can remain on an item for a long period of time. We don't know how long that car was out in the public. Could have been for months. And that fingerprint could have been placed there at any time before that.
Let me ask you this. What about the fact that the alleged victim here testifies that he did not know the people who attacked him? He never met them before. First time he saw these individuals was at the gas station that day.
Right.
So could the jury reject the hypothesis that your client's fingerprint was put on that car at some other random time because there was no connection between the two of them prior to the day of this incident?
Well, I suppose a jury could make that determination, but I still think it calls for a lot of speculation to say that that fingerprint was put on there at the time of the crime, commission of the crime, when the car's been out in public for obviously weeks or months and could have been touched by anybody, and obviously was touched by numerous people who may or may not have a connection to Mr. Thomas. Now, the video is the Commonwealth's other evidence. I think we've sort of discussed that already. You can, as we discussed, you can tell the person's basic size, what they're wearing. And if you use the zoom feature, it does blur the video even further. I can't tell if the person is a Hispanic male. I can tell there's a fight going on, but I can't tell there's a stabbing from looking at the video.
Do you have any idea, by the way, when I'm watching the video, one of the cameras kind of zooms in and zooms out and pans around. Is it being operated by a person? How does that, or was it manipulated afterwards, or do we know anything about that?
I don't know anything about that. I did notice that. I don't know why that is.
So no, I agree with you. It's sort of circular that the fingerprint, that the man that was your client who placed the fingerprint because the fingerprint is there, and your client. I mean, and some of the cases, Morris and the one with the DNA, those sort of help you. But could you address the Duong case, which is quoted passim in the Commonwealth's brief?
Well, the Duong case, I think, is different because in the Duong case, they find the defendant in the area, I believe, the next morning, and he's hiding, I believe. And I think right after the crime, they find two other people who were involved. There were 4 people altogether. They find them in the area with the stolen goods, I believe, and a firearm. So I think in that sense, it has some similarity in that there was a fingerprint found on the door, but I think it's different because these people are all found in the area shortly after. And there's no connection with my client of finding him anywhere. So I would differentiate Duong on that basis. I think the cases are very favorable to me. The French case, the Morris case, and the Anitas case are favorable for me, especially, and even Anitas, even though it's a DNA case. In that case, there was a video that they said wasn't real clear. It showed somebody throwing something down. They find the defendant's DNA on those items. They said that wasn't sufficient to show that he was involved in the crime. And the DNA is like fingerprints. It stays on an item for a long period of time. The second issue in my brief is that the improper question by the prosecutor to the fingerprint expert created a substantial risk of a miscarriage of justice. Trial counsel didn't object to this question, which was surprising because he brought it up in the pretrial conference 2 days before jury impanelment about what the expert should be able to say and what he can't say. He did object to the statement that there was a match, and he also objected to any fingerprint evidence coming in at the pretrial hearing and when the expert started testifying. Now, the DA admits in his brief that the question was improper. It was supposed to be a reasonable degree of fingerprint analysis certainty and not scientific certainty, stated by the Robertson and Armstrong cases. But the assistant DA in his brief states that there's no substantial risk because the fingerprint was not seriously in dispute, which I would say is not correct because trial counsel, when he cross-examined the expert, extensively cross-examined him about his education, training, and experience in trying to show that he wasn't trained and educated enough in fingerprints and that there could have been an error made by him in this identification. And he also argued in his closing...
So in light of all of that vigorous cross-examination, it was vigorous cross-examination of the fingerprint expert, would the jury really be... Would it make a difference that he said it's scientific certainty versus fingerprint certainty? Whatever that means.
Well, it makes it sound like it's a science, which it really isn't. It's concluding that it's a scientific certainty that it's his fingerprint instead of a fingerprint analysis certainty, which I think is a lesser proof. So I think it could have made a difference to the jury. I think it's different from the Robertson case in that in Robertson it affected only undisputed evidence, and in this case the fingerprint was undisputed in Robertson. In this case, the fingerprint was disputed that it was my client's fingerprint. I also argued the judge should have acted sua sponte as soon as the question was asked because it was the judge who, in her ruling on the motion in limine, wrote down Robertson and Armstrong cases. She knew what the law was, and she didn't do anything to interject before the expert gave an answer. The judge is supposed to ensure that it's a fair trial and that inadmissible evidence is not heard by the jury. And obviously the fingerprint, in this case, the statement about the scientific certainty on the fingerprint is very important because the fingerprint is the principal evidence in the case of identification.
Isn't that a slippery slope, asking judges to weigh in and sua sponte? I'm even having trouble seeing how that would work in a courtroom. And I think that that could really impact a jury if all of a sudden the judge is making sua sponte either remarks or bringing counsel to sidebar. How would you?
I think it happens
to request that.
I think it happens quite often that the judge says something about either a question or an answer that's not admissible and calls the parties to the sidebar. I think that happens quite a bit.
In May, a follow-up question to that would be, is that when a judge does something like that, sua sponte, sometimes counselors are not so happy about it.
Well, I think in this case, since, like I said, I don't know why trial counsel didn't object. I said since he brought it up, but I don't think he would have been upset if the judge had interjected there and stopped the expert from answering. There's no further questions?
Hold on, I'll check with the panel.
Ask you to reverse the judgments.
No further questions, thank you.
Thank you.
Morning. May it please the court. Assistant District Attorney John Wendell on behalf of the Commonwealth. If there's no preference from the court as to which issue I start with, I'll start with the sufficiency issue. The law here is very straightforward. The question that the court really needs to address is whether that particular piece of law applies. The law is that where the fingerprint is the only identification evidence, the Commonwealth must prove that it could not have been placed at any other time. Problem here is that the fingerprint is the only conclusive and specific identification evidence, but there's other evidence strongly backing up that identification. There's the fact that the individual in the video is approximately the same size, height, and build as the defendant. He's also, with regard to what you can see in the video, you can tell that he is a dark-haired individual of a lighter skin tone. Which, like, I'll just say his skin tone is notable in contrast to that of Mr. Thomas and Mr. Abdul Rahim, who have much darker skin than him. You can tell that from the video, and regarding the quality of the video, yes, it's a lower quality video. It can be zoomed in, if the way that software works, and this was explained by Mr. Riggins, the forensic video analyst, if you click on a single panel of the four, and then you can zoom in by scroll wheel on a particular portion of the video in question. It does pixelate it as you do so.
Was there an explanation at trial of that one camera that zooms in by itself and pans?
I don't recall if that's in the record. Do
you have an explanation of it?
I believe that the answer to that is that the cameras are subject to live control by individuals who have the ability to monitor that. I know that in some cities, at least, cameras of that type may be viewed by police officers and controlled live. Some of them, I believe in other cities, may be somewhat motion activated and pan to motion.
Simultaneously, like while the event is happening?
Well, the event is happening, yes.
So someone have to call in and therefore then somebody then manipulates the camera? Or?
Theoretically, something to that effect, yes. Right. Alternately, someone might have reasons of their own for manipulating a camera in a particular way, choosing to use it to surveil a particular location for an ongoing investigation, something to that effect. Again, I don't know that this is in the record, but that is my understanding of how these cameras work based on other cases.
Yeah, that's a tangent, sorry. No. So, I mean, for you, would you say Duong is your best case?
Yes.
Okay.
Absolutely.
And so how do you respond to Mr. Methe's distinguishing that, well, in that case, they actually found the guy nearby the next day?
Well, he's found nearby, but he's found nearby 8 hours after the fact. And there's nothing particularly suspicious about what he's doing. Some of his answers to some of the questions are a little bit confusing. He gives an explanation for what he's doing there that doesn't entirely make sense. But there's nothing overtly criminal about what he's doing. I disagree with defense counsel's characterization of the defendant's behavior as hiding. He's sitting on a porch. So,
Okay, and then how do you distinguish cases like in Anitis and Morris, where you've got a vague description of the person that could have been there at the time, but based on very
So
and they leave something there.
I guess I'll answer as to the two cases separately. With regard
Okay.
to Morris, the defendant did not actually match the description of the individual who was wearing the clown mask, with a mask upon which the defendant's thumbprint was found. He did not match that description. He was of a different build, and that is noted by the Supreme Judicial Court that he doesn't actually match the description of that particular individual. And the judge's instructions in Morris were that the jury could only find the defendant guilty if they found that he was the individual wearing the clown mask. There's no real question in Morris that the defendant had left his thumbprint on the mask at some point close in time to the incident. But there's evidence that this assault, for lack of a better word, is planned beforehand, that there's people coming to the scene separately, leaving separately. The defendant is associated with the other individuals involved in this. So there's evidence to support the idea that the defendant left the thumbprint on the clown mask at a different location, gave the clown mask to a second person, the second person used the clown mask, and given the judge's instructions, there's sufficient doubt as to whether the defendant is the individual wearing the clown mask that the jury could not have found him guilty beyond a reasonable doubt. But again, that's given the judge's instructions. Had the jury been instructed on the issue of joint venture, it would have been a totally separate question. With regard to Anitis, the problem in Anitis is that the video in that case is of such poor quality that all that can really be told is that someone of some vague possible maybe resemblance to the defendant leaves an item of unknown specification in this parking lot. The police arrive, they find in that general area 2 items. The defendant's DNA is found on those 2 items. There's actually not enough evidence in Anitis to establish that the items from which the police recovered the defendant's DNA are the items left behind by the assailants, much less when the defendant's DNA was placed on those items. In this case, in contrast, and I give the specific timestamps down to, there's actually a frame-by-frame method of moving the video along, so you can see the exact moment the defendant, or the individual who the Commonwealth alleges is the defendant, the assailant, as he exits the vehicle, he closes the door very obviously with his right hand, and he is the only person in the course of the video who is seen touching the door frame on the lower portion of the exterior of the window, the location from which the fingerprint is found. The other individuals involved in the incident, all 3 of them, all touched the upper portion of the door frame out on that exterior edge. But the assailant, who we allege is the defendant, is the only individual who touches the location right there. And again, this incident happens very shortly before 6 p.m., and then the police respond to the hospital at approximately 6 p.m. So it's a matter of minutes between when the fingerprint is placed and when the police arrive and secure the vehicle. So again, this is very, very comparable to Duong, where the individual closes the door, the vehicle is secured, and the defendant's fingerprint is found at the location that the fleeing suspect touched immediately before the vehicle was secured. So it's very comparable to Duong. It's distinguishable from Morris and Anitis. It's extremely distinguishable, I would argue, from French, because there's absolutely no evidence in French regarding who committed this break-in. Aside from the fingerprint, there's no description. There's an hours-long period between when the window was last seen and when the fingerprint is recovered. So I would suggest that all of the cases are fundamentally distinguishable that the defendant relies upon. If there are no further questions on that issue, I'd move on to the issue of the particular question. And I want to be...
Mr. Method wanted the judge to act sua sponte. Robertson says the prosecutor should act sua sponte without even an objection from defense counsel.
I agree with that. I will say, however, I struggle to determine whether this is actually an error, given...
How do you struggle about that?
Well, because...
It's error.
Well, the thing is, Your Honor, in Robertson and Armstrong, they recommend reasonable
Prosecutors
degree.
are supposed to follow the recommendation of the Supreme Judicial Court.
I would argue that the prosecution is encouraged to follow the recommendations, that a recommendation is the ideal to which we should strive. A requirement is the floor below which we may not fall. And this is a recommendation, not a requirement. The requirement of Robertson and Armstrong...
And if I were to say to you that's really a distinction without a difference, would that change your mind? Because I really hope you go back to your office, which is a well-respected office, and say, let's follow what the SJC recommends.
I absolutely agree that the Commonwealth should follow the recommendations of the SJC. That's a separate question from whether it's a legally cognizable error upon which the defendant may rely in obtaining relief on appeal.
Well, we can agree on this. It should not have been said.
I will agree that...
We'll go from there.
I will agree that the question would have preferably been stated the other way. I will certainly agree that the question should have been stated the other way. It would have saved everyone a substantial amount of trouble. However, the ultimate spirit of Robertson and Armstrong is to make it very clear that the testimony of the fingerprint examiner is an opinion rather than a fact, and that there is some fallibility, some subjectivity to fingerprint evidence. And in that respect, the spirit of Robertson and Armstrong is followed. It is very clear from the way the question is phrased, from the other testimony, from the information brought up on cross-examination. It is very clear that this is the officer's opinion, that there is some subjectivity to fingerprint analysis, that fingerprint analysis is subject to error. There's a discussion during the testimony about a well-known case in which there was an erroneous identification and conviction based upon fingerprint analysis that was non-blind. All of that information is before the jury, so the jury has all of the information to establish that this is a subjective opinion, not a clear scientific fact, the way that this substance is cocaine, for example, would be considered a scientific fact. So ultimately, the jury has the information they need to analyze whether the fingerprint is actually the defendant's fingerprint, whether the officer's opinion is an accurate opinion. And in that respect, it's very different from Fulgium, from Haunch. In those cases, the opinion testimony was presented as if it was fact, as if fingerprint analysis is entirely reliable, no subjectivity, no unreliability. So this case is very different from those cases. And ultimately, in this case, fingerprint, there was an argument about, well, can you even rely upon this? But the fingerprint was assumed to be true for a substantial part of the defense attorney's closing argument. And his argument was instead, who cares? It's a fingerprint, yes, but who cares? It's on the exterior of a vehicle that's out in public all the time. It could be placed there at any point. And that is the defense that is raised at trial. It's not, it isn't his fingerprint. It's, even if it is his fingerprint, who cares? So ultimately, in the circumstances, because the jury was aware that this was an opinion, and because it ultimately was not central to the defense counsel's argument, I would suggest that, assuming that the question as it's phrased is error, that it is not an error that gives rise to a substantial risk of a miscarriage of justice. And I'll just say with regard to the suggestion that the judge should have sua sponte intervened, that would simply be another claim that error occurred. It would not be a specific basis for concluding that a substantial risk of a miscarriage of justice occurred. If there are no further questions, I see I'm running low on time.
One moment, I'll check with the panel. No further questions. Thank you both very much for
Thank you
your
very much.
argument. All right, the next case involves the Department of Children and Families versus another and versus mother. I remind everyone that this case is impounded, so please be very careful not to use any names of the individuals involved. It's case number 2025-0155. And I just want to double check on the time allotments here. So I see that the Assistant Attorney General is going to take 10 minutes, is that correct?
That's correct, Judge.
Okay, and Attorney for the Child, 5 minutes? Thank you very much. All right. Good morning.
Good morning. May it please the court. My name is Lane Goldberg, and I represent the appellant mother in this case. This case involves the swift termination of mother's parental rights as to her child, M. On the first day of trial on July 1st, 2024, almost a year after her removal, mother on her own had secured a spot in a residential treatment facility that was really geared towards having mothers and children reunify within that program. She was in compliance with her action plan provided by DCF. She was in compliance with the program, and she had full accountability, and this was according to DCF. Full accountability. She had insight as to why M had been removed and why she was in the care of DCF. And so at that point, at the trial, because of her recent positive gains, mother asked for a short continuance, specifically 2 months or so. But the trial judge denied her request, and this denial was 3 months after DCF had asked for the same relief, and the trial judge had allowed DCF's request. That original trial was scheduled for March 25th. But I want to back up and just present a little bit of a timeline here as to what transpired. And I want to start with the date of February 7th, 2024, and that's when DCF changed M's goal, the internal goal for M, to adoption. On that same day, the ongoing social worker Carvalho, met with mother and told her that the goal had been changed. And mother said directly to her, I feel like, you're not responsive to me, you haven't helped me up until this point. And social worker Carvalho didn't really offer any concrete assistance, but the theme that she would present to mother is, I need you to be consistent. Be consistent in these programs. Consistency is key, is what she would tell.
Did she not, at that point, was the mother also informed that that could change? The decision to move from, to actually put the child up for adoption could change, could be reevaluated?
The change, yes, and DCF has a duty to concurrently plan for reunification, and that was mother's social worker. So an adoption social worker was assigned to M, and mother's social worker was social worker Carvalho, and expressed to her, consistency is key, consistency is key. And during that month of February, mother reached out multiple times to the social worker asking for an in-person visit, provided the address, said meet me anytime. The last one was February 29th. She reached out again and asked for an in-person visit. Social worker didn't respond, so again on March 5th, mother contacted the social worker and requested to meet with her. And in that communication, she directly told the social worker that she felt like she was trying to juggle everything, she had no support, and she was experiencing stress. And the social worker, again, didn't offer concrete assistance, no referral was made for anything, just said consistency is key.
Can I ask you, just following your story and the dates you give, is that what evidence in the record supports those? I mean, did the mother give specific dates of when she contacted the social worker? I doubt that. Yeah,
so the record it's actually pretty clear. It has
where is it? Where is it? Yeah.
It has the court reports, and its record, it's right around 433 to 436 are these communications, and it's the social worker that's copying and pasting the emails from mother.
That's helpful, thanks.
Yes. So on that same day, she said consistency is key, and that was the main point that was raised. And so shortly after that, mother, on her own again, without the assistance of DCF, checked herself into behavioral health. It was an inpatient mental health facility. This was her second stay there. And from this placement on, mother demonstrated more consistency. A trial was scheduled in this case for March 25th that I had mentioned.
Interrupt you for a second. What do we do with the fact that for the 6 or 7 months prior to that period of time immediately before trial, that there was not consistency and that she left or was asked to leave programs, that she had a period of incarceration? What do we do with that? Do you think the judge was only supposed to look at the 90 days prior to trial? Because I think we can all agree that that's not the standard. We look at all of the circumstances, correct?
Yes. So, Your Honor, you're correct. She had a rocky relationship with those prior placements. There were hospital stays. There were 2. One of them, in both of them, she had left on her own. There was a fight in one of them, and then she had left one of them on her own because she couldn't take her prescription Adderall, and she decided that she needed those. Those 2, and she had testified as well at the trial, that the placements that she was put in, those were basically sober homes. The last placement that she found on her own, Casa Esperanza, was a placement that really had comprehensive care, and then from that, its sister program, Latinas y Niños, is a program that she found again on her own that she could reunify with M, and that again, it had therapeutic help for her.
I have a different, just a factual question, and since you've brought it up, I'm going to interrupt you and ask you now. It was that second program part of the Casa Esperanza? And so did she have to leave and go to a new program, or was it just a continuation, really, of the same program, but in a different setting?
It's, from what I understand, it's an affiliated program of Casa Esperanza. So it's a program, the Latinas y Niños is in Boston. It's an affiliated program. So she did leave, she went immediately to that program from Casa Esperanza.
Okay.
And also to answer Justice Allen's question, I would look at Adoption of Paula that provides that when terminating parental rights, a judge must consider the present circumstances, taking into account the recent positive gains and the likelihood of future improvement. And what's notable here is that when she asked for a continuance, the trial judge denied that motion to continue. And the trial judge does have discretion in denying or allowing motions to continue, but what I would say here is that she abused her discretion in improperly weighing those factors in making that decision. She abused her discretion knowing that she had just granted the request for DCF's continuance, asking for similar timing, and then denied mother's request for the same thing. And part of her discretion, I would argue, is treating everyone fairly in this case. So I would say that there's a flagrant injustice to that, especially, yes.
When the Commonwealth asked for more time, did they arrive at the trial and say we reschedule, or did they file a written motion? This one was done, they arrived for trial, it's done orally, there's no written motion, right?
Yes, so it was a written motion from DCF about a week prior to the trial. And that request was so that it could bolster its case against mother and put this on the termination track. On the day of trial, yes, mother's attorney did request a continuance, but again, its fundamental rights are at issue here, and the judge had the discretion to continue this, especially where her decision was basically it indicated too little too late. You're not staying at these placements, and I don't think that you're going to stay at these placements. Why not give her the chance to prove herself that she could stay at these placements? The decision said an alleged, quote, substantial and permanent improvement, her pattern of leaving these placements. She finally got into this place, and again, it was on her own. She found this on her own after begging DCF to help her.
Before your time is up, I have one more question for you. And that is, in the beginning of your argument, you indicated that at the time of trial, mother demonstrated that she had an insight into why her child had been taken from her. And I don't think that the judge found that during the course of the trial, and I'm not so sure that the mother's testimony establishes that she had an insight. In fact,
So-
I think she contradicted some of the evidence in terms of the child's substance exposure, et cetera. So when you say the mother demonstrated she had insight, what exactly in the record are you referring to?
I'm referring to social worker Carvalho's actual testimony. That's at the transcript testimony 169 to 170 and 177 to 178.
Okay,
is
thank
what I
you.
have in my notes
Right.
as far as where that testimony came from. She had been asked a question about does she have full accountability, and I think that the answer was yes, and
Okay,
that
I'll
she
double check
provided
that.
insight.
Thank you.
If there's
You have one section of your brief, you list, I don't know how many clearly erroneous
Yes.
findings of fact you're contesting. Which ones are which are the most important that we should look at?
So I can point out those findings. Finding 12,
Just, if in the interest of time, the most important ones.
I would say the findings dealing with that mother never stayed in either a short-term or long-term facility more than a few weeks at a time. That's finding 12. The most important also is that finding 17 states that mother has a lengthy history of substance and alcohol use, and the record does not provide that, this lengthy
12,
history.
17? You can give us just the numbers because we'll
I can
correspond.
give you the numbers, yes.
Ones that
Finding-
are, as follow Justice Massing's suggestion, the most important ones.
Yes, finding 12,
17,
17, finding 13,
okay?
and then there's finding 197, because she did not use substances within the past year. That's not in the record at all.
Okay.
And then there are some findings related to the reasonable efforts that were made by DCF.
Okay.
And I can give you those as well. 183, 207, and then there's a slew of them regarding to communications. I can give you those, but
That's okay, no.
the other ones are the
We
most
wanted to hear
important.
the headlines there, not that we'll ignore the other arguments at all. We'll look at it very carefully.
I understand. Thank you.
And just one more question. Can you shed any light on whether the child was or was not in the NICU in the 6 days that after she was born?
She was not in the NICU. She did not go through withdrawal at the hospital, and even DCF had admitted that she was not in the NICU. That was at the trial transcript 45 and 197, one of those pages where DCF admitted that she wasn't in the NICU.
Okay. Thank you.
Thank you.
Anything else? Justice Massing? No. Anything else? All right, thank you very much.
Thank you.
Good morning, Your Honors.
Good morning.
Your Honors, the department contends that the juvenile court properly concluded that mother is unfit to parent child and that termination of parental rights was in the child's best interest in this case. The department's history with the child goes back to 2015, and involves neglect of child's older siblings, in part as a result of mother's continued struggles with mental health challenges, housing instability, unemployment, and unacknowledged, in part, substance abuse. The children were removed from mother's care after mother had consumed alcohol and had tragically engaged in self-harm at a time when the children were experiencing homelessness. They had slept in a vehicle the night before.
These are, of course, you're talking about the other siblings, not the child who's the subject of this petition.
That's correct, Your Honor. And at that time, mother was also recorded engaging in a heated argument where she made threats to her sister from the front of the vehicle with the children in the back seat. Shortly after that, during visitation, the children were again in unsupervised visitation. Mother did not return the time when the children were again in a vehicle.
Given the time constraints, maybe you could focus more on this child and the events that surrounded the removal of this child from mother's care and what happened at trial.
Yes, Your Honor. So as a result of this continuing through mother's pregnancy with this child, mother was reported, had a psychiatric episode and reported to hospital staff that she was unhoused. While pregnant with this child, at the time she had recently undergone a incarceration while pregnant with a child. And during this episode, she tested positive for substances like alcohol, cannabis, cocaine, benzodiazepines and codeine, none of which she had been prescribed. She would later be diagnosed with alcohol use disorder rated severe use, cannabis use disorder rated mild use. And at the time of child's birth, mom tested positive for these two substances again, alcohol and cannabis, in addition to benzodiazepines and codeine, again without a prescription. The child was born substance exposed to amphetamines, likely as a result of mother's prescription of Adderall at that time. But the child was also born not breathing and required care in the NICU. There was testimony from one of the witnesses for the department that the child had been at the NICU. And there's also the notes.
Where's the testimony that the child had been in the NICU?
I don't have the citation to the transcript.
What witness? What was the name of the witness?
It was not, opposing counsel is correct that it was not Carvalho. I unfortunately, but I do cite it in my papers, and in support of the finding by the court that the child had spent 6 days in the NICU. And the court also finds that the child was...
Well, that's sort of important because I think that the allegation, the assertion is that that fact is clearly erroneous, right?
That is correct, Your Honor. I do cite in my papers support from the transcript. It's also in the notes from that time period that the child did spend 6 months in the hospital. And the court
6 days.
Or sorry, 6 days. My apologies.
Okay, that's all right.
Yes, in the hospital, and the court could certainly credit that the reason that would be is to provide child care to the child, health care to the child, that the child needed that care. Mother, nevertheless, at trial testified that the child was born completely healthy. At that time, when the 51B investigation was conducted, and mother denied taking many of the substances she would later test positive for, including cocaine and the benzodiazepines, and she explained the cocaine consumption by perhaps by saying that perhaps her cannabis use, that her cannabis was laced with cocaine. And so mother at that time it was also discovered she had a pending arrest warrant. She was staying with a friend. And so at that time, the child was removed on a temporary basis. The department intended for mother to reunify with the child, as mother had done with the child's two older siblings at the time of an earlier removal. Mother was incarcerated at that shortly after in 2023, and then
What were the charges that she was incarcerated on?
the charges involved mother engaging in assault and battery with a police officer. I believe that there was resisting arrest. There was some sort of engagement with police. The record does not show any conviction as to that, and that's not one of the bases that the court relied on, I don't think, for terminating parental rights here, but it speaks to housing and to the instability of the home that the child would be introduced to. After that, mother admitted she was drinking a lot in September of 2023, so there was a relapse there prior to her admission from the South Bay House of Corrections and to Bournewood.
I think we could agree, and I don't think there's any disagreement, that there was a tumultuous situation up until the time just prior to trial.
Sure.
Right? And so I think that that's well documented, and again, I don't think it's really disputed. But the issue is that right before trial, there was a period of time where one could reasonably infer there was some stability, some attempt to stability.
Well, to go back to February, which is the time that opposing counsel was focusing on just now, at that time and during those discussions, mother was, in those same pages from the record, mother was communicating that she felt that DCF was biased against her. She was not yet showing any sort of understanding as to the circumstances for which her children had been removed, including child here. And mother also had misrepresented that she was receiving services like from Alcoholics Anonymous and Narcotics Anonymous, which she later admitted that she had not received.
Again, focusing on the 3 months in which she was enrolled in Casa Esperanza and then moved to the affiliate program of Los Niños and Niñas, if I'm not mistaken. There was some improvement. Would you agree that was established in the record?
We agreed to that at that point. Mother had been tested during her stay at these programs, and she did not test positive for alcohol or consumption of other substances.
So what is your view then? I mean, I know exactly what you argue in your brief, that the motion to continue was appropriately denied and not abuse of discretion. But shouldn't the in this case, a little more attention be given to the fact that there were those recent gains and that the case was not that old of a case. The child was only 1 year old at the time, of course, always deserving of permanency, but we see cases every day that have gone on for years before a decision is made.
The court could properly, when we cite to adoption of Alyssa, the court had discretion not to extend the trial, and it could properly do so with the interest that it had for the child to obtain permanency. That was the factor that the court weighed most heavily. It also took into account the extension would be a 2-month extension of time, and that during those 2 months, the court did not think or did not assess that mother's history of significant parenting deficiencies would necessarily, be overcome. That this was not necessary for the court to adjudicate the issues, and so the court could properly, in weighing the factors, decide not to extend the date of trial. There's no question, and the court does not weigh it against a mother that she did not relapse at that time, but right before. There was a relapse, again, right after February, right before her admission into Casa Esperanza.
You've answered my question, and your time is up. Let me check with the panel, see if they have additional questions.
I do, yeah.
Go ahead.
If I may.
Yeah, please.
So there's case law that says, you have to raise a reasonable efforts claim, before prior to trial. But on the other hand, the reasonable efforts that the mother says weren't made are things like visitation, services, contacting the mother. Those are things that that you don't have to ask DCF for, that DCF should be providing all along. So what were the efforts that, what programs did DCF refer the mother to?
So a mother was repeatedly in short-term placements where she was looking to secure a long-term placement that would be able to provide her all of the services that she needed. She was always
mother or DCF did that?
Mother did so with DCF.
Justice Massing is asking you about DCF.
That's right, but while this was happening, DCF was met with mother whenever possible, tried contacting her when it had contact information. Mother did not always provide that. Scheduled child visits whenever it was feasible. In fact, there was a child visit scheduled at transitions, and then approximately 1 day after the department found out that mother had received or had obtained placement at her initial long-term placement in Stepping Stone, the next day or two thereabouts, the child visit happened, and DCF had at one point offered visitation when mother had left a short-term program at the DCF's office, and mother refused visitation with the child. DCF, whenever possible, engaged in the home visits with mother, but there were some programs, including Casa Esperanza, that did not allow in-person visitation. And so what you'll see happen more often in the record is virtual visitation where feasible, and when in-person visitation, with the department, and when in-person visitation is allowed, then with the child. It was not feasible in part because of the short-term nature of all these programs and some policies that they had in place. The court did not...
I think we'll check the record now. I have one more question for you. In your brief, you say that you concede there were gaps in communication with the mother when a department social worker went on vacation or when a new social worker was assigned. Are those typical of gaps? Isn't there like a contingency plan for when that happens?
It's not typical, Your Honor, but again, this was not weighed against mother by the judge. And I think that in this circumstance, a mother was able ultimately to secure placement at many placements that could have led to her receiving the services that she needed. But unfortunately, she left a number of them, relapsed when she went back to Worcester Behavioral, and it was not like, as observed earlier, until the eve of trial that mother secured location at a long-term program where she could receive all the services that she was seeking earlier on in this case.
All right. Thank you.
Thank you.
Any additional questions? All right, no additional questions from the panel. Thank you very much. We'll hear from the attorney for the child.
Good morning, and may it please the court. I'm Sherry Krasner. I'm appearing on behalf of the appellee child. Attorney Aronis, who had been representing the child throughout the appeal, fell ill earlier in the week. I'm a CPCS appellate mentor, and I'm filling in her stead.
Okay, well, thank you for being here.
Certainly. We ask that the court promptly affirm the judgment. Let me just address a few points that have come up during the argument with respect to the child's time in the NICU. On page 26 of the child's brief, she talks about the fact that the number of days that the child was in the NICU, that the judge got that wrong, but certainly in the context of 288 findings, that one misstatement is not relevant to the court's ultimate findings. As to the continuance, this was the request for the continuance made.
Right, can we just go back to the NICU for a second? I just want to try and drill down on that. So do you agree that the child was never in the NICU? And so all of the findings that were made relative to the NICU are erroneous?
No. She says that the number of days that the child was in the NICU, I think they say that she was there for 6 days and she was there for fewer days. But it's not that the child was born in some distress. The child tested positive for substances. So you do. Could I just ask that you speak into the mic? I'm
So
sorry.
you believe that the child was born substance exposed?
Correct.
Okay. And there's a disagreement on the number of days that the child was in the NICU?
Correct.
Appears. But there are a lot of findings where the mother's argument with the social worker is regarding how many days she was in the NICU. She was saying she was not in the NICU for 6 days, or she was, and the judge seems to put a lot of emphasis on how strongly the mother feels about that, and her argumentative nature, and her, and I think that probably would be something that a mother would find an issue with. Can you address that?
But the judge also found that this mother wasn't a credible witness too. So I'm not sure. Certainly I could understand how that would anger the mother, but this wasn't a case about how many days the child was in the NICU. And this was a child, mother didn't, or she tried to contest that she hadn't used substances throughout the pregnancy, but that certainly was not true. There was evidence that she did use substances while she was pregnant, that she, in fact, not only used substances, but there was a serious overdose attempt. So.
But you would agree also that the child, even though there were substances in the child, it was not cocaine.
Correct.
It was substances that the mother was prescribed.
Correct. Correct. But the child was still in distress as a result of the mother's substance misuse of other substances. I was talking about the continuance. The continuance the request was made without any affidavits, without any offers of proof. If, for example, they came and said, well, an affidavit for someone at Casa Esperanza saying this mother has made extraordinary progress in her brief time with us, and we expect XYZ to occur over the next few months, and the judge denied that request, perhaps there would be more to the...
In your experience, how typical would that be, that for a motion to continue where there's undisputed that the mother at that point, or either any parent, is in a program and the attorney represents that the person is doing well? Is it typical then to have more than that, to have affidavits from people who are taking care of the person, et cetera?
Certainly, and particularly this was an 11th hour request. This was a request made, at the first day of trial. And if you'll remember too, there were 2 days of trial. The first day was at the beginning of July. Second day was at the end of July. Counsel didn't request that the record remain open. My mother had testified on the first day. There was no request that the record remain open, to have someone from the program come in.
That would have been another full month.
Correct.
4 months.
Correct.
But the record did, after the 2 days of trial, did reflect that mother was doing pretty well at the new program.
Right, and she was. But I think what's happening, what counsel argued today, what he argues in his brief, is that there's another way to look at the evidence. And I'll even concede that that's true, but that's not the job of this court in doing appellate review. You have a deferential attitude towards what the trial judge said, and what this trial judge said is that this is a mother who's been involved with DCF since 2014. Her 3 older children came under guardianship with their maternal grandmother because of mother's involvement with DCF in the months between July 2023 and July 2024. Mother was in 9 different placements, and mother doesn't have a history of being successful in any placement. So that's how the trial judge looked at the evidence. It's supported by the record, and I would ask that this court, in doing its job, it's simply to affirm the judgment because the findings are supported by the record.
One moment. Further questions? The panel has no further questions.
Thank you. I'll rest on her brief, though. Thank you very much.
All right, but before we take our recess, I'll just say the panel knows these cases are very difficult. We know how hard they are for everybody involved, and we will as we do in every case, pay very close attention to all the details. And so thank you all 3 for your arguments today. All right, the court will stand for its morning recess. All right, our fourth case on the list is case number 2024-0514, Claire DeLoid versus Francis Ellis Jr. and others.
May it please the court, my name is Robert Kraus. I'm here for the appellant Francis Ellis, and I'm here today to ask you to employ your powers to provide justice to my client. I want to touch on 4 issues: the jury instructions, special verdict slip, prejudice, lack of evidence, duplicative damages. Your Honors, Justices, I understand the standard for 51B in the jury instructions, but the overwhelming cause of justice, the manifest justice issue, the clear error here, based upon the civil conspiracy instruction, which doesn't include the Cooker standard, which clarifies Potter, which says that in order to...
You started by saying you understand 51B or A or whatever it is.
51B.
So what you understand is that this was not raised at trial, right?
I understand, Your Honor, that yes.
So isn't it waived?
It's waived to the extent that unless it creates a manifest injustice. And it's a very high standard. I appreciate the standard. But here I believe that you have a clear injustice that would be perpetrated unless unless the correct law was applied to the standard of civil conspiracy.
Okay, and I'll let you get there, but so on that, manifest injustice. So that would be basically the standard for a motion for new trial. You did file a motion for new trial.
Yes.
And the judge denied it.
Yes.
So the issue would be, if we're looking at it at all, it's whether the judge abused his discretion by denying the motion for new trial.
Correct, Your Honor.
Okay, all right.
Because it is plain error. If you look at Cooker, which corrects Potter, the essential element is knowledge of the tortious plan. I'm not going to repeat all the facts, but Francis Ellis knew James Ferreira. He wasn't named in the criminal matter. The alleged actions occurred between 2005 and 2010 with Ms. DeLoid. The testimony, the clear testimony that he provided at the trial was that he never met Claire DeLoid. He didn't know her. He didn't know about a fake lottery ticket. He didn't know about any efforts on behalf of Jamie Ferreira to defraud her or where Jamie Ferreira's money's coming from. Now, in this instance, the civil conspiracy tags my guy jointly and severally for a lot of money. Based on what? A CDU, maybe a fictitious Cadillac that's in Exhibit 76 that is if bid, a Bobcat, $20,000, $30,000, and the real estate deal for 72 Sandwich Street, which is part of the fraudulent transfer finding by the judge. The evidence went in uncontroverted that Ellis put in $45,000. He borrowed $80,000 because Ferreira owed him $22,000, and he paid him back. And then he put $150,000 into the property to develop it because that's what he did. What happens? During the course of his testimony, the last 2 days leading up to the jury deliberation, he is questioned thoroughly about his tax returns and business operations by my brother. The relevance of that escapes me, and it was allowed in over objection because it doesn't show any knowledge, any relevance to create a civil conspiracy. Handful of deals.
Doesn't it show that a consciousness of guilt, that there was some money in there that he was hiding?
Your Honor, let's say that, first of all, it went in over objection. There were no expert about his tax returns and his financial dealings over the course of 2 days. And even my brother in his closing apologizes for embarrassing him. Because he's bad at accounting or because he might have done something unrelated to Claire DeLoid does not create an inference that he was part of a scheme to defraud Claire DeLoid. Again, we're talking about a handful of transactions over a 5-year period, which makes him liable jointly and severally for tons of money. Remember, it's part of the argument, and I think we briefed it, but the notion that my guy could get a fair trial where Jamie Ferreira had already been convicted, spent 5.5 years in jail, had already been summary judgment out. Judge Cosgrove entered summary judgment for over $1 million before the trial started. So why, in fact, was the trial principally about, and this goes to the prejudice, principally about the criminal matters associated with Jamie Ferreira? And the testimony, again, is very clear. My guy had no knowledge of Claire DELOID. He never took title or owned those few pieces of equipment. And I appreciate the standard of circumstantial evidence. And the judge says it in his instructions. If somebody's in a dark room and somebody walks in, there's no windows, and someone walks in and they're soaking wet with a raincoat, must be raining outside. Fair inference. What's the inference here? That my guy maybe didn't do his taxes right, had a couple of deals with Ferreira for nominal amounts of money in relationship to the amount that's claimed and that was found against Jamie Ferreira, and that he did a real estate deal where he actually put $45,000 of his own dollars in, took a loan, repaid it, and then invested another $150,000.
Can I just ask, did you, the issue of the knowledge, was this part of all of the post-trial motions that you brought?
Cooker was not raised in the post-trial, to my knowledge, in the JNOV and the motion for new trial. The Cooker standard was not raised.
The issue, because you spent a lot of time speaking about knowledge, just, today, and if we were reviewing that motion, was that addressed in that motion?
Well, Justice Allen, the notion of applying the correct standard at the time of these decisions, because the judge ultimately created the resulting trust based on fraud and the civil conspiracy, is one where, again, it's this notion of manifest justice that the right legal standard has to be applied. The notion, I know you'll read the transcript because of the pro se defendants and the chaos here and the days spent drilling down on the criminal activity of Mr. Ferreira, made it almost impossible for my client to have a trial free of bias or prejudice such that it would not lead to a new trial.
So I know this procedural stuff is kind of a problem for you, but there was no objection to the criminal stuff coming in against.
There was.
There was?
Yes, there was, Your Honor. In fact, if you read the opening, before the jury was even impaneled, there was a discussion about the extent to which the criminal matters would come in, and they were objected to. And then there was objections to a number of the exhibits which dealt with the verdict, the guilty finding, and the other matters.
I haven't read the entire transcript, but I did look where the guilty plea or where the judgment came in, and there was no objection at that point.
I think that throughout the course of the trial, particularly as it came to Mr. Ellis the last 2 days, there were objections raised associated with this process. And that's it, I think 165, 170, somewhere in that range on the transcript.
So the position at trial was, I don't want evidence of Mr. Ferreira's criminal conviction to be in, but I do want the jury to know that he's been ordered to pay $1.1 million.
Actually, it was just the reverse, Your Honor. Mm-hmm. The amount of the summary judgment never was disclosed to the jury.
Right. That's what you want. That's what I'm saying. Your position at trial. Your position at trial is, I want the jury to know that that summary judgment of $1.1 million has entered against him, but I don't want them to know that he did anything criminal.
It would have been preferable. Again, it was not done. It was not done. And again, the ultimate standard here is a new trial where the verdict is so markedly against the weight of the evidence as to suggest that the juries were swept away by prejudice, bias, and it led to an unreasonable conclusion. That's the Tripp case, 34 Mass App, 744, 748, 1993 case. Reading the trial transcript and the post-judgment motions, it is inconceivable, I think, under the manifest justice standard that Mr. Ellis could have gotten a fair trial given the introduction of the criminal matters, and I will call it the persecution based on his financial record. He may not have done everything right. He may have done some wrong things on the IRS or reporting income, but that doesn't provide circumstantially that he, in fact, colluded with knowledge of a tortious plan to rip Claire DELOID off. And he wasn't part of the criminal process. He wasn't called. This case has been going on since 2011. You know, you can imagine what the interest is. My client is fighting to have a trial free of the taint of Jamie Ferreira and to determine reasonably and with clear reckoning of the present law whether in fact he, with knowledge, schemed with Jamie Ferreira to steal from Claire DELOID from 2005 to 2010. And the only evidence that came in was that there were these, again, the Sea-Doo, the Bobcat, a Cadillac, maybe.
In your brief, you make a brief reference to the, and you mentioned it here, to the if bid. Explain that to me. I didn't really get it.
Car dealers are, as you well know, are a world unto themselves. And there's an Exhibit 76, which was used by my brother in his closing, references another Cadillac that was the subject of and associated with this malfeasance. It's an if bid. You know, I'll buy that if. It wasn't purchased. It was just a contingency deal. There was no acquisition of the asset. And if there's no acquisition of the asset, Claire DELOID's money couldn't be used for it. So that again, is on the order of a red herring. I'd like to think, Your Honor.
Just if you could help me, I mean, I can't. I don't know if you can really see. That's the document.
Yeah.
It's teeny. Where, like, what direction should I look to find the if?
I think it's in the top of it, Your Honor. It does say if bid. There's an element to it which makes it a contingent transaction, and I think it is 76.
Yeah. So it's on the top somewhere.
I think so, Your Honor. I can pull it up. Because I carry it on
I'll get out my magnifying glass.
But, and I should tell you that, you know, there was question on the damages. Now, my brother raises the fact that, you know, the jury, the trial ended on Friday afternoon after 11 days. Jury goes in, comes back with a question of damages. Judge says, use your best judgment. Now, my brother says that's not in the record. Well, actually, if you look at paper 216, Judge White's decision on the JNOV and new trial, he in fact says that's what he told the jury.
I think what's not in the record is the discussion at sidebar about how to handle the jury question.
I'm just referencing the, you know, that the judge in fact uses that in his decision to deny, when he denied JNOV. And it's dated September 3rd, I think, 2023. Your Honors. So again, just to try to wrap up and pull it together, my client had no knowledge. There's only circumstantial evidence, if you consider that at all, of a tortious plan to defraud Claire DELOID or keep her or frustrate her purposes at collecting money on her property. That's Jamie Ferreira. By a scintilla. If you look at the record again, Ellis, all the witnesses, no one says, including Claire DELOID, who had a complete memory loss because by that time she had had surgery for brain and it was disclosed, and she's an elderly lady, and she remembered certain things, but not others, and she had no recollection of meeting Francis Ellis. Ellis, again, had no understanding, knowledge of any fraudulent loans, $4 million
So you need to wrap
lottery
it up now.
tickets. I hope that you take into consideration these arguments on behalf of my client for justice. Thank you.
Just let me check. Question? Thank you. Counselor?
Thank you.
Do you want this?
Oh, sorry. Thank you.
Good morning, Justices. May it please the Court, my name is Joseph J. Coppola, and I represent the plaintiff appellee, Claire J. DeLoid. The main point that I intend to make today is that virtually all of the arguments in the appellant's brief and that we heard here today were not raised below, or at least not properly raised below. In some instances, they're raised for the first time on appeal.
I think there's substantial weight to that argument, and I don't know how much it's worth you spending time explaining all that. But could you, if you could address, particularly, what about the objection to the criminal conduct of Ferreira coming in? Was that is that waived, or
They're actually during the trial? First of all,
he said mention look at the opening statements.
During the trial, Jamie Ferreira's criminal conviction came in without objection. And Jamie Ferreira was questioned about his criminal conviction. That all related to what I would call evidence of the underlying tort, the fraud. At that point in time, Judge White had not decided that he was going to take the fraud and the breach of contract claims that were decided by virtue of the criminal findings. He did not indicate that he was going to take those from the jury's consideration. So that was all tried. To your original question, there was no objection to any of the questions that came with regard to the criminal conviction.
And if you could just, your trial counsel, could you give me the elevator talk of what was the evidence of Ellis's knowledge of the fraudulent conduct?
Well, I'll speak to it generally. Of course, you start with the proposition that, civil conspiracy, often the only evidence you get is circumstantial evidence. And I pointed to the fact that, number one, there were hundreds of thousands of dollars obtained from my client by fraud. In at least 3 instances, there's evidence that the money that he took from Ms. DeLoid, that Jamie Ferreira took from Ms. DeLoid, was found in the hands of Mr. Ellis, at least 3 instances.
And those
One, with the purchase of a Bobcat excavator. It's a small kind of construction equipment. One was a Sea-Doo watercraft, like a jet ski, that was put in his name. And another was a piece of real estate put solely into Mr. Ellis's name. So we know he's involved there.
Involved, though, how? In other words, anything that Jamie Ferreira did with that money and with any other person would also be part of the civil conspiracy? I think Justice Mastin is asking you to concentrate on circumstantial evidence of the knowledge.
Yes. The circumstantial evidence of the knowledge is that, one, he's the end user, the beneficiary of these funds.
Okay, and from that you make the inference.
That's one piece of the puzzle. Another piece of the puzzle is that, and Mr. Ellis testified to this, he admitted he knew that Jamie was someone who liked to hide his identity, and that he would ask for Mr. Ellis to be the front man on some of these transactions. There was also, aside from checks that went directly from my client to Mr. Ferreira to Mr. Ellis, aside from that, again, hundreds of thousands of dollars were taken from her and used by Mr. Ferreira to purchase cars at auction. And who allowed Mr. Ferreira to get auction access? That was Mr. Ellis. Mr. Ellis did it through a company called Route 6 Auto Sales. That was a company in which he was the limited partner and his brother Peter Ellis was the general partner. So he was going to auctions where with Mr. Ferreira, where Mr. Ferreira was using my client's money. It was also true that he was allowing.
I never understand money laundering. How did Ferreira use your client's money to buy cars at auction?
She would write him checks.
Oh, your client's money.
My client would write Mr. Ferreira checks.
He wasn't using Ellis' money.
Or he would ask her to write a check to himself and herself, and she would cash it and give him the cash.
Okay.
This was all based, she was loaning him thought she was loaning him these monies based on the fact that she thought she had security in a fake lottery ticket and other things.
And so in the, I like, again, acknowledging that there's a substantial question of whether this is even properly before us, but count 3, $151,000 conspiracy, count 9 or 10, 10-9, $126,000 fraudulent conveyance. Are those the same monies or different monies? Like,
they're not the same monies, and there's no way to know that.
What is the evidence underlying each one, if you could?
So you could point to, on the record, transactions. I'm going to start with the $20,000 check for the excavator that Mr. Ellis used to purchase an excavator. There was a $15,000 check that was used to purchase the Sea-Doo. There was $80,000 that was used to purchase the real estate and was put solely in his name. Now, in terms of the fraudulent conveyance, Mr. Ellis testified that the other $45,000 for the purchase of the real estate came from him. He testified to that, didn't produce a single document. It's important to understand that the entire property, which was valued at $125,000, that was the purchase price, was put in his name alone. So, and when you talk about fraudulent transfers, it was based on the jury instructions and the law, it was his burden to prove that he was a good faith purchaser for value of the asset, being the real estate. So it was his burden. And on that point, the jury did not have to believe the fact that he said he contributed the other $45,000. Again, no documents. We don't know anything about that. So all of that adds up to more than the $126,000 judgment received. But again, if you go back to the special verdict questions that were asked, Mr. Ellis never asked anyone to itemize that.
Right.
So there's really no way to know for sure how they got there, but I'm telling you, what I'm arguing is there's evidence to support it. Now, in terms of if you would like me to address the
151,
the $151,000 on the civil conspiracy. Given a civil conspiracy, if you find someone liable for civil conspiracy, they can be held liable for the entire amount, liable for whatever their co-conspirator is found to have done. That could have been $1.1 million, which Mr. Ferreira was found liable for on the fraud. But as the evidence showed, my sort of explanation for this is why they didn't hold him liable for the full amount was that really the evidence started in 2009 of Mr. Ellis's sort of pervasive involvement in these transactions that were being used, that where my client's money was being used. So it was about in 2009. And if you look at Exhibit 1, there are numerous transactions, checks written directly to Jamie Ferreira. You could look at those. If you just take August 2009 forward, those amounts are well over $151,000. They're over $200,000. So, and it was those checks, those have nothing to do with the fraudulent transfer claim. It was those checks that it was alleged he took from her by fraud during this time period, and Mr. Ellis was involved in these transactions. And so that's you could use. Again, we don't know how the jury got to that.
Right. Could you actually trace some of those post-2009 checks to auto sales? Or not quite?
No, they were not traced directly to auto sales, but Jamie Ferreira testified that he was using the money that he was taking from her as loans to buy automobiles at auction, used automobiles at auction. So we have that testimony. And it was actually Mr. Ferreira's testimony was that he was in business with Ms. DELOID, which she denied. So that was his explanation for that. But I also do want to go back to the knowledge question, which is that when it came to those transactions that he was using, that Ferreira was using Mr. Lloyd's money at auction to buy, those were also run through Route 6 Auto. And I point to the fact that with regard to those transactions, running them through Route 6 Auto, the general partner, somehow, the general partner had no idea. Mr. Ellis's brother, Peter, no idea, and that's what he testified. I didn't know that Francis Ellis was doing all this. So that's, again, circumstantial evidence. They were hiding what they're doing. I would suggest it's evidence of consciousness of guilt. You know, many ways that you can interpret. The jury could have interpreted that. And along those lines, also the tax returns, okay? The judge could have, and the jury could have looked at those tax returns and the fact that he wasn't reporting his income as something against his credibility. And they could have disbelieved, you know, evidence of a extraneous matter can be used, of wrongdoing, can be used to impeach someone's credibility. And I cite the case in my brief. I don't have it ready here. But so the jury, when he says, I knew nothing about it, the jury could have disbelieved him. On top of, we have a lot of things connecting him to all of this.
So the tax records were introduced for impeachment purposes and not for, or also for consciousness of guilt?
The tax returns were, the tax returns fit more into the fraudulent transfer claim, where my client's obligation was to show that Mr. Ferreira was making these transfers with intent to defraud future or present creditors.
They were introduced for all purposes. Is that what you're saying? Okay.
Yeah, so it could be used to impeach his credibility, but it showed that Mr. Ellis shared in Mr. Ferreira's intent to defraud, and that was a necessary thing that I needed to prove in order to get a judgment against Mr. Ellis for the fraudulent transfers. They needed to show a shared intent.
Okay.
But I guess as to all the arguments, and I hope I did a good job dissecting all the arguments in the brief. None of them were raised properly below. And the standard of miscarriage of justice does not apply in a civil case. The only evidence that you'll see, or the only reference that you see to the application of that standard is in criminal cases. It doesn't apply in a civil case. If the issue is not raised below.
It does apply for a judge to throw out a verdict and give a motion for new trial. The judge has to find that there was a miscarriage of justice. I mean, it's a very high standard.
It is a high standard, and
the judge found that it did not. The judge specifically said there was no.
Yes, but but I'll also point out, we're here on appeal, obviously, but the arguments that were made as to knowledge were not made in the motion for new trial. There's no reference to that in the motion for new trial. So that issue wasn't even raised there at all.
I'll check with the panel if there's any further questions. I see none. Thank you both very much for your argument. We'll take the case under advisement.
Thank you.
All right, I'm ready to call the last case on our list for this morning, and that's case number 2024-1176, Charles J. Husk versus a member of the Zoning Board of Appeals and another.
Excuse me.
Good morning, members of the panel. May it please the court. My name is Brendan Cook. I represent the plaintiff appellant in this matter, Charles J. Husk.
I'm going to have to ask you right from the very beginning to see if you can, there you go, you know exactly what I'm going to ask, right? Okay, thank you. If you could talk into that a little bit, it would be helpful.
Yes, Your Honor. My name is Brendan Cook. I represent the appellant in this matter, Charles J. Husk. We're before you on an appeal of a preliminary injunction entered by the Plymouth Superior Court in an underlying zoning appeal. I'm going to address the three arguments that I raised in my brief, but prior to that, I'd like to address an argument raised by my sister counsel here in that this wasn't actually a preliminary injunction entered by the Plymouth Superior Court, and that we're not properly before this court on this appeal.
That would be a good place to start, right? Okay.
Essentially, the argument runs that this is a condition of the motion to stay that was granted in favor of my client, and essentially ties into the allowance of our request that fines be stayed and that the structures be allowed to remain on the property pending the outcome of this appeal before the Superior Court. One issue that I raised with that is that there's no language in the order signaling that it is any kind of condition on the two favorable orders for my client, right? There's no language in there that indicates that as long as there's no commercial use at the bungalows or on the property, there'll be a stay on fines that issue or on the removal order. In addition to that, I would argue that Chapter 40A, Section 17 specifically, in the second paragraph, authorizes the Superior Court to enter orders that affect the zoning appeal even before we get to final judgment in that case. I would argue that the orders staying fines and removal of the structure fall under that authority. So really, we're just replying to my sister counsel's claim that we essentially were granted a preliminary injunction in this case, in addition to the condition in favor of the town.
So were you saying that you agree that your motion, even though not styled as a motion for a preliminary injunction, was de facto a motion for a preliminary injunction?
No, Your Honor. What I'm arguing is that Chapter 40A, Section 17 allows the Superior Court to enter orders that are just and equitable relating to zoning appeals that are properly before it. Our motion for stay essentially was made under that authority of the lower court to enter essentially a stay of fines on the basis that if the fines were not stayed pending the appeal before the Superior Court.
What do you say the standard is on a motion to stay in the lower court? Because your motion does not address what the motion that you brought did not address a standard, and it asked for a variety of relief.
Yeah, so the motion for stay was based on prior case law from the appeals court, this court, Commonwealth v. Graziano, which indicated that there's presumption is the wrong word, but essentially courts look on in favor of staying the enforcement action by the town pending the appellate process playing out. And in that case, it specifically had to deal with a criminal complaint brought by the zoning enforcement officer or the building inspector to enforce the zoning bylaw. So procedure, it was a little different, but I believe the principle underlying Commonwealth v. Graziano stays the same in that absent a showing of tactical delay by the appellant in the Superior Court, there is in favor of staying any kind of enforcement so the appellant doesn't have to face the choice between potential fines accruing through an appeal or foregoing the rights of an appeal and just complying with whatever orders entered by the court. So just to address that point or tie a bow on it, I would essentially submit to the court that the order from the Superior Court that the fines be stayed and that the structures stay in place were authorized by Chapter 48. They weren't a preliminary injunction. Differentiating the third condition, which was that there's no commercial use of the bungalows during the pendency of the appeal, there's no underlying connection. And this sort of rolls into my first argument in the brief, in that there needs to be a nexus between the injunction that's issued in the underlying case. And that really stems from the likelihood of success on the merits, that portion of the standard, the preliminary injunction. Ultimately, the underlying case here, the ZBA appeal, is an issue dealing with the town of Duxbury's Wetland Protection Overlay District. Mm-hmm. So it's a zoning district that affects certain areas in the town that are deemed...
Actually, didn't you already lose that one? Isn't this appeal about the order to take them down?
Yes, so the order to take them down was based on, it was issued immediately following the denial of a special permit to maintain structures in the Wetland Protection Overlay District. And my client's argument before the ZBA, in response to the appeal of the enforcement order, was that the structures and the utilities cited as requiring a special permit have been removed from the Wetland Protection Overlay District. So they were essentially located in the Residential Compatibility District in Duxbury, that no portion of the structures touched the Wetland Protection Overlay District, and they're allowed as of right as an accessory structure on his property without any kind of intervention from the town or special permit, anything like that.
So is your current appeal of the teardown order a collateral attack on the prior denials of permits?
No, because the permits were required when the structures were located in the Wetland Protection Overlay District, and there was a site plan conducted by my client, submitted to the town, and then ultimately submitted to the court through our complaint that shows that the structures have been removed from the Wetland Protection Overlay District. So there's no special permit requirement. So our appeal of the building inspector's enforcement order, which was based on the fact that we did not have a special permit to maintain the structures in the Wetland Protection Overlay District, was that the issue was mooted because the structures had been removed. They've been placed on a portion of the property that are in the Residential Compatibility District. There's no special permit requirement. Ergo, the enforcement order is moot because the underlying reason has been removed. The ZBA heard that appeal. They disagreed with us. They upheld the enforcement order, and the appeal followed to the Superior Court. So the issue before the Superior Court is really whether the ZBA validly upheld the enforcement order in light of the structures being removed. I don't believe there's any dispute between any of the parties that the structures are no longer located in the Wetland Protection Overlay District and that they're accessory structures allowed as of right in the Residential Compatibility District. So really it's the proprietary or the ZBA is upholding the enforcement order that's before the Superior Court. I give the background of the special permit really to focus on the nexus that I'm talking about, in that there's no issue of commercial use in the underlying appeal. There's no, the enforcement order issued by the zoning enforcement officer, the decision by the ZBA, it didn't touch on any kind of alleged improper commercial use going on at my client's property. It was solely based on the bylaws special permit requirement for the Wetland Protection Overlay District and specifically maintaining structures in the Wetland Protection Overlay District. So to include that, essentially there's no world where the town gets the relief in a final judgment that it got through this preliminary injunction, in that the court's going to order that no commercial use take place at my client's property.
Well, if the bungalows are taken down, no commercial use will take place.
I'm sorry, what was that, Your Honor?
If the bungalows are torn down, no commercial use will take place.
Well, there's no evidence of commercial use taking place in the bungalows to begin with. And as I said...
So no problem not doing it, right?
There is no problem, but the issue here, and we get into it in the brief, I won't rehash all of it, there's litigious neighbors that really were the spark for this dispute between my client and the town, in that they brought the enforcement request to the ZBA that was sort of the first interaction between my client and the town on this issue. There's been enforcement orders filed by the same abutters with the Conservation Commission and the Board of Health, really dealing with the same complaints that they brought to the ZBA and couldn't get the relief they were seeking on. So his concern with the fact that this order is in place is that the abutters have been effective in getting the town to be their enforcement arm in seeking the results they'd like to see happen.
At any time, did the neighbors bring up the issue of commercial activity?
In their original complaint, yes. It wasn't related to the bungalows. Well, there was an allegation that there was rental of the bungalows going on, but there was no evidence submitted by them outside of a photograph that there was a laptop in one of the bungalows.
What evidence was presented with respect to commercial activity?
There was evidence of screenshots of Airbnb listings. So there was no direct evidence that anyone was paying money to stay there. They were just essentially listed online, which were older and I believe at that point had been taken down, or at least inactive, but were still available through the website. But again, those listings weren't for the bungalows themselves. It was a different portion.
So that evidence just concerned listings for Airbnb listings, but not other commercial activity?
There was an allegation as well of a dining event, which the town permitted through one-day alcohol permits. I believe porta potty permits were issued. So there was there was never a finding that was an improper commercial use of the property. I believe on the basis that the town issued permits for that event.
So your point is that's not really relevant to the issue here?
What was that? Sorry, Your Honor.
The point is, I believe your point is that commercial activity that's alleged is not relevant to what is at issue here.
No, specifically with the town's requests that my client be enjoined from using the bungalows in any kind of commercial way. And I'd like to highlight as well, this is a sort of abnormal process for this because the town still has the avenue available to them if evidence is presented to the zoning enforcement officer that there is commercial activity going on that involves the bungalows or any other part of the property that allegedly violates the town's zoning bylaws. The avenue is still fully available to any abutter, to the town, to submit an enforcement order or issue an enforcement order through the zoning enforcement officer and be subject to the statutory appellate process through the ZBA or the planning board and then ultimately the Superior
But isn't the current order from the zoning board or the enforcement officer is that there be no commercial activity, correct?
That there be no commercial activity involving the bungalows.
Okay. And so isn't the judge just reaffirming, essentially, or maintaining the status quo?
Well, this is actually a good point. My client's issue with the fact that there's an order here is that the neighbors have been litigious. They've been effective in getting the town to take the enforcement
So I understand that there's emotions, but isn't it just a reaffirmation, her order, a reaffirmation of what the status is? And it's just the status, maintaining the status quo. Because my sense from reading her order was that you don't want the fines to accrue, understand, and that you have case law that supports that, and you made that pitch to her, and it made sense. And I do have a question about the actual order, but there would be no fines, and that the buildings remain where they are. That's the status quo. Nobody has to expend monies to raise them. But also the status quo is maintaining what the orders are of the town. And so where it seems sort of no harm, no foul.
Well, I would argue there is some limited commercial use that my client could make of the property. It's a different avenue, but essentially the Dover Amendment protects agricultural use, and he could also use it as storage, either in the agricultural context or...
I don't think the neighbors are worried about him putting in crops in there. I think they're worried about having a 200-person wedding.
I understand that, but the language of the order is very broad in that it's commercial use, and it opens him up to a new avenue of enforcement, which is essentially motion for contempt. And if there's an allegation that he's violating the order, instead of issuing the enforcement order through the town zoning official in going through the ZBA. It could be done as a motion in the court seeking contempt against my client for any kind of alleged commercial use. Again, on a pretty broad-based order.
And was there a request to the judge for the judge to maybe make a finer point on that he could use it for agricultural purposes, but of his own use? Did you go back
There was a
to the
motion for
court?
reconsideration filed, more on the basis that this was just an improper preliminary injunction that entered. I don't believe we requested that there be a more specific definition of commercial use. And I see my time's getting low. I know you had another question that you wanted to get to. I'm happy to answer it if you'd like to raise it. Sure. So just to the second part of my brief, I'll cover it briefly. I think it's spelled out well in our papers, but procedurally and substantively, there's issues with the preliminary injunction as well. And that, really the meat of that is the reasonable likelihood of success here. Essentially, putting aside the fact that there's really no outcome here that grants the town an order that there's no commercial use of the property. This is really an appeal of whether or not the ZBA's decision upholding the enforcement order is correct on that special permit issue. Our client has shown a likelihood of success on that claim, and the town has not shown that it's likely to succeed sufficient to obtain a preliminary injunction in defending the claim or the challenge of the ZBA's order. Specifically, there's mention in my sister council's brief regarding that there was never a zoning permit issued. There was, in fact, a zoning permit issued. It's in the record as an attachment to or an exhibit to the complaint. It was issued on October 14th, 2021, and it was never revoked by the town. So there was a valid zoning permit that covered the bungalows on my client's property. It was gotten through working with the building commissioner, who advised them on where to place the structures and how to actually construct them to be compliant. And that was issued and invalid, so I see my time's up, unless there's any other questions.
I'll check with the panel, see if they have any follow-up questions for you.
Thank you.
I just have one question, which is this injunction or condition, it entered in a year and 3 months ago, and then the litigation just stopped. Why?
I believe because we were subject to this appeal, Your Honor. Ultimately, I think this will be something decided on the papers as to whether or not.
So there's the thought is that because the preliminary injunction part is being appealed, you can't go to the merits. That's the understanding. Should we enter an order saying go ahead to the merits while we decide this appeal?
We'd be happy to proceed if the court would like to enter an order that we proceed to the merits, pending the decision. Yeah.
Okay. Question. Thank you very much.
Thank you, Your Honors.
Good morning. My name is Robin Stein. I work at KP Law, and we represent the town of Duxbury, including their zoning board. And I appreciate you taking the time to hear this today. I'd like to start my comments in the same place that Attorney Koch started his comments, and that is that this is not a preliminary injunction. The plaintiffs came in to the Superior Court under the general concept that courts have equitable jurisdiction to use their discretion to issue interlocutory orders during the pendency of cases, and specifically under 4817, which allows such orders, and asked for the court to do that. And we, in response, simply said, generally, we're not opposed to it as long as you just remind them they can't use these for commercial use. And I think it's important to look, it's on page 61 of the record appendix, that's specifically what the relief was that Mr. Husk asked for. Mr. Husk asked that the court grant their motion and enter an order staying the imposition of fines relating to the bungalows, period.
Could you give me that page number again, please?
Sorry, sure. It's 61 in the record appendix. It's in the conclusion paragraph at the bottom of the page. The relief that was sought was that the town not be able to issue fines, the zoning board or the zoning enforcement officer, related to the bungalows during this lawsuit. And so, first of all, this is not a preliminary injunction. The condition that the court put on the allowance of the stay motion, as you've noted through your questions, was a protection to the town, reminding the Husks of the already unquestionable legal truth that they can't use these bungalows for commercial uses, and it strikes an appropriate balance in the court's discretion, simply acting on an order, issuing a stay, that the town have some protection if that unlawful use were to happen, because we shouldn't have to go through an entire another process of issuing a cease and desist or going to a zoning board.
Sorry to interrupt, but do you interpret the judge's order to be limited to commercial activity with relation to the bungalows only?
Yes, because it says the plaintiff shall not use the trailer/bungalows as short-term rentals or in any commercial use pending this appeal.
So any commercial use there is only related to the bungalow?
Yes. So they're limiting, it's not limited to the whole property, which is a misrepresentation in the plaintiff's papers. The order was specific to the bungalows. The order essentially said the town's not going to issue any fines regarding these bungalows. They can stay where they are, whether you fight out if they're in an illawfully placed location on the property. But remember, you can't use them for commercial use. That's all it is. It's a reminder of an already existing legal truth, but it's not a preliminary injunction. And I don't frankly understand the argument that the first two parts are not a preliminary injunction in favor of the plaintiff, but somehow the third part is a preliminary injunction in favor of us. And I think there is a risk in this case that if we treat something like this as a preliminary injunction, every interlocutory order that a superior court issues during the pendency of a case is suddenly going to become immediately appealable, and I don't think that's the intent of the law. This is simply an order. This is an order within the sound discretion of a trial court judge to act on a request to benefit a plaintiff during the pendency of a case with some protections to the defendant. Because without that protection in this, the town would be limited in its ability, where the bungalow is used for commercial use, to simply issue fines or take zoning enforcement. And our only recourse would be to file a new zoning enforcement action in court. The town has already, as you noted, gone through the administrative process, which they're not required to do, but they did, and that is usually how towns do it, of issuing a cease and desist, that the Husk appealed to the zoning board, and that the zoning board upheld and said you cannot make commercial use of this property, and they didn't further appeal it. The town's not going to go through that process again. That's final. So if we can't fine, our only recourse is to the courts. That's all this is leaving in place, whether it's through a contempt or a new action. The town's recourse is to the courts. So again, I start with this as not a preliminary injunction, and it shouldn't be before you. But even if you determine we're here and it's something that you're going to decide, this type of safeguard, this type of condition, whether you call it a condition 3 as a condition on conditions 1 or 2, or it's simply a condition of the order, is totally reasonable and totally within the sound discretion of the judge. Now again, understanding the underlying issue in this case is that the town of Duxbury requires a zoning permit before you specifically place properties. And I don't believe that any zoning permits that have previously issued, certainly not one in 2021 because they were in the Wetlands Protection District at that time, has authorized the placement of these properties on the plaintiff's property. And it's curious if that's the only issue between the town and the plaintiff, that they haven't simply come in and just filed the paperwork and mooted the case at this point. So they're using this stay to infuse delay in this case so they can be use of those bungalows free of fines without that condition is the delay we're seeing. There's no reason this case hasn't been completely litigated to finality. There's no reason this case hasn't been mooted if they just need to file the paperwork. It appears delay is the intent, and they should not be able to continue in the delay of the case and be free of a safeguard to the town, and at the same time not be advancing the case in any way. But in any event, the condition is wholly related to this case, because as you pointed out, Justice Massing, if the bungalows are not there, there is no risk of commercial use. So if they were removed as they were ordered to be removed, we wouldn't be at risk of commercial use. And so there should be no question that the relief relates to the case, but it certainly relates to the relief they asked for. And I think that's what's more important. What's more important is that the relief that was sought was to limit the town's ability to take zoning enforcement. And so a condition on that relief that offers the town protection against needing to take that zoning enforcement is certainly related to the case, and it is certainly related to the motion that was before the court. And there's no question treating it simply as a discretionary order of the court that the condition at issue was entirely appropriate and entirely within the sound discretion of the court. Now, even if you look at this situation as a preliminary injunction, and to answer your question earlier, I believe the case law is that motions for stay technically follow the preliminary injunction legal standard. I don't think they're often in practice done that way, but there is case law supporting that the kind of analysis a court goes through and considering a stay should track a preliminary injunction. In any event, this would still be warranted, because when a town seeks a preliminary injunction, even though we didn't in this case, but when a town does, the two issues are likelihood of success on the merits, and then whether or not granting the relief is going to advance the public interest or it's going to create harm to the public. And again, this is a very simple issue. In order to place these structures on the property, a zoning permit approving the location of those structures needs to be obtained from the town. And that's important because you file the application with the town, you show exactly where they're going to be, which in this case is an issue because they have moved around the property, and the building inspector has a full and fair opportunity to then say, I have a plan and I know exactly where it is, and I can determine the zoning districts, and I can see that you're free to go. And that's what has not yet happened, and particularly important in this case because the property is located in multiple zoning districts, and these structures have moved around the property. So
I think you answered a question that I had, but I just want to clarify. The answer to Mr. Cook's argument that this is, as of right, is that you still need a permit. You still need a building permit.
You still need a zoning permit in this case. I believe the structures are under 200 square feet, so they wouldn't trigger the building code, but Duxbury requires the zoning review nonetheless to ensure that the structures are lawfully placed. And in this case, I don't believe there's any evidence, and I don't believe they've obtained the necessary zoning permit, which is an administrative process to give the building commissioner an opportunity to review the size of what you're putting there, is it lawfully placed, all of those things has happened for the current location of the bungalows since they were moved out of the Wetlands Protection District.
You mentioned something about something attached to the complaint, and
I don't believe that anything issued in 2021 can possibly be the current accurate location of those because they were originally placed in the Wetlands Protection District and then moved. So if what we're referring to is the 2021 permit, I don't think that corresponds to the current location. If I'm wrong, I'm sure there'll be some correction, but I don't think that that's the same location that we're talking about now. Again, if the plaintiff's position is that the only thing standing between them and not having an issue with the town is getting a new zoning permit, I don't know why they haven't just come in and filed the paperwork. And I can't speak to that, but that, as far as I know, that hasn't happened. They could cure it and moot it, and here we are a year and a half after the stay motion, and we're still talking about this condition that just repeats a legal truth that hasn't caused anybody harm and isn't harming anybody. And that really brings me to the other part of the preliminary injunction standard. We are likely to succeed in this case that they have not obtained a zoning permit. We're going to succeed on the merits of that. And beyond that, it's certainly and unquestionably within the public interest for the town to enforce its zoning bylaws. And there can't be any argument that the public is going to suffer any harm, even if you treat Condition 3 as being a preliminary, in the nature of a preliminary injunction, by merely restating that you can't use the property for commercial use, which without question has been problematic to the public because you've heard that abutters have had issues with it. And you will see in the record here, there are references to a wedding, I believe a bridal shower or baby shower. There was a commercial dinner. To say there was no evidence of commercial use when there are advertisements for Airbnb and such things, that is evidence of commercial use. So again, the question of whether or not the property can be used for commercial purposes is resolved and it's final and it's beyond reproach. Whether or not it ever will be again, that's a different issue. But to say that throughout the pendency of this action, for which the plaintiffs haven't done anything to move it along or advance to finality, the town is limited in how it can take zoning enforcement against those bungalows with no protections, it seems unwarranted. And it seems to me to be entirely within the discretion of a superior court judge to say, yes, it makes sense. We're not going to make you bear the expense of taking these out. And frankly, we weren't asking for that. The town was not pushing, which is pretty consistent with the usual practices. When a zoning board decision is advanced to court, unless there's some imminent threat, we don't usually push for any future action. We wait until the case is resolved. So we weren't pushing for the bungalows to be taken out. We weren't actively finding the bungalows. They chose to come into court seeking that protection for the reasons they chose to do that. But I don't think we would practically be in any different position right now if these papers have, never been filed. I really am having
I have a question about the fines. Do you believe that the stay is on billing or on collection? Because if you ultimately are successful, is the appellant then going to be on the hook for 3 years of fines?
I read the order saying we can't issue fines.
So no, you can't bill.
We couldn't. So normally the fines are done through the.
You can't fine.
Yeah, it's like the 21D process where you.
So it's not fined, but so it's not accruing.
Yes, I mean, I read that as saying we cannot issue daily fines. Like, normally the fines are done through the Chapter 4021D process, which requires you to issue like a daily fine that can be appealed to district court, and that wasn't happening. They didn't. I don't believe that they came into court to stop active fining. It was they chose to ask for that relief, and I guess an exercise of caution or concern. But you know, again, it just seems to me that we're really arguing about more of an intellectual than an actual issue, and in this case, I think procedurally and substantively, the court. Well, I think the court accurately and appropriately, using their discretion, issued an order that strikes an appropriate balance between giving relief that they were seeking that we weren't opposed to, so long as we had some safeguards, and we got that safeguard. And in coming to you, I think procedurally and substantively that order should be affirmed, and I think this appeal should be dismissed. I still don't think it should be here. I don't think that we can call every interlocutory order an API just because a court ordered something. And I think that is a dangerous potential consequence of this appeal.
You called it an appropriate balance, but when I think of a balance, I think of somebody wins something and somebody else loses something. Would you characterize it as just maintaining the status quo?
Well, yes, I agree that it's just maintaining the status quo, but when I say it strikes an appropriate balance, it's because it did take away from the town an enforcement avenue. And if you're going to take away from the town an enforcement avenue and leave us only with litigation, which is costly and expensive for the town to have to undertake just to have zoning enforcement, then that's where I say I think it strikes an appropriate balance, because the town did lose something. The town lost a very administrative avenue for zoning enforcement through this order. I think it's fair to say, we just remind you, you can't use it for commercial purposes, because that's the thing we'd be most concerned about enforcing against. And honestly, in this, the town's on the shorter end. So I understand that the plaintiffs, don't like that being in there, but it's not causing them any harm. It didn't change anything in the law. There haven't, as far as I'm aware, been any issues in the last year and a half since it's been sitting there. We haven't gone to court to enforce anything. And, it seems to be an intellectual debate. But in any event, I don't think that there's any basis in law.
Can I just ask, I expressed it in the prior argument, I am a bit concerned, and you guys might be right, that the filing of this appeal stays the action in the Superior Court, but I'm concerned that it did that. I mean, there was no reason why you couldn't go ahead and litigate this while this was pending. Would you be opposed if we were to issue an order saying, go ahead and continue to litigate while we decide this?
No, actually, I don't think this stayed the litigation at all. I think the plaintiffs are the plaintiffs, and they should have been advancing this case. But as a town who has to balance how its municipal resources and limited resources are used, and as the defendant in a zoning case, we don't tend to take the laboring oar. If the plaintiff wants to advance their case, they should advance it. I think the plaintiffs are using this case to delay so they can keep the bungalows there and not, for whatever reason, go file for the zoning permit. I absolutely think the case should proceed, but I don't think we need an order to do it. They could do it at any time. Thank you very much.
Thank you both. I see no further questions. Thank you both for your arguments. We'll take the case under advisement. That concludes our sitting for today. I want to thank everybody and the court staff for helping us out today and assisting us in hearing all these arguments. And the court stands in recess.
Thank you.